Okay. All right. I expect we might see a few more people log on, but we do have a good number here. So once again, this is the Dellino Law Group webinar on prenuptial agreements, postnuptial agreements, and cohabitation agreements. My name is Melissa Rosenberg, and I'm joined here by Michelle Dellino, the owner and manager of Dellino Law Group. And I am a mental health provider who pairs with the firm and takes referrals from the firm and helps people with their emotional crises alongside their family law crises. And so I work with both individuals and with couples in all stages of their divorce process. And I'm here to help moderate this webinar today. I'm going to have Michelle introduce herself in just a minute. And then what we're going to do is have Michelle get started with some content about our topic today. And then as Michelle is delivering the content and giving you guys a bunch of information, please feel free to ask questions. You can put them in the Q&A. And if you put them in the Q&A, you can mark yourself as anonymous if you choose, or you can leave your name. It's up to you. I think only the hosts and panelists can see the questions, just so you know. You can also put your questions in the chat directly to me if you'd like. And I will pitch the questions and we'll try to answer as many of those as possible today. All right, so again, I'm Melissa and I will turn it over for Michelle to introduce herself.
Hi, thanks for coming today. I'm Michelle Dellino. I'm a family law attorney. I do a great deal of postnups, prenups, and cohabitation agreements. I think it's a really important topic because most people don't have one. And when you don't have one, then you end up having to be involved in a much more contentious, expensive, and often what we would call litigious divorce to determine property rights, spousal maintenance, all kinds of things that could be avoided by a valid and effective prenup, postnup, or cohab agreement. So it's an important topic to talk about. A lot of people think, oh, I don't need a prenup. I don't know what that is. Or that's something that's going to be really difficult for me to talk to a potential spouse about. But, you know, really anybody could benefit from one. And it doesn't necessarily, first, just before we talk about the specific areas, I'll tell you this. A lot of people are extremely negative about the idea of a prenuptial agreement. And some of the things I hear are, oh, it makes me feel like I'm planning on my marriage to fail. Or it makes me feel like I am trying to keep something from my partner. And really, neither of those things are necessarily true. The way that I look at prenups as someone who does divorce litigation is to tell you that a prenup's like an insurance policy in a way. You don't carry appropriate levels of liability insurance because you think you're going to get in a car accident or hit someone or hurt someone. You do it so that if something happens, you're protected. And I can tell you that litigating at the end of a divorce or committed intimate relationship is extremely expensive. Post-divorce things are expensive too, but many divorces and committed intimate relationship cases could be avoided by a prenup, postnup, or cohab agreement. So the way to look at that is to say, you know, you and your partner are doing this now when things are not contentious and in the hopes that you never use it, but to decide between the two of you how you want your property and assets to be divided and to not leave that up to the courts, and to also to promise each other that you're not going to spend literally thousands of dollars each fighting about it. Because money that you spend on legal fees later is money that you don't get to keep or divide amongst yourselves. So there's a lot of good reasons to enter into these agreements. I'm going to talk about prenuptial agreements first. That's the most common. And then we'll move on to postnuptial agreements. And then we'll finish up talking about cohabitation agreements and just a little bit about committed intimate relationships as well, because that's kind of connected to a cohabitation agreement. So a prenuptial in Washington state. It's important for you to know that what a prenup is. A prenup is basically, it's a marriage contract to safeguard the rights of individuals before, after, and even during a marriage. The protections can cover assets, property, and those are kind of the main things, also spousal maintenance. So an important thing to know too is that Washington courts don't like prenuptial agreements. They don't. And so the reason why I can explain to you, but essentially Washington has declined to enact laws that will affirmatively allow people to alter their rights through a contract. So in the void of that, what the courts have done is they've given us through numerous cases a framework that outlines how to deal with prenuptial agreements. What I mean by the court has declined is the court has basically said, we're not just going to say if you write something down and call it a prenup, we're going to say it's good. The court has a framework to make sure that these kinds of agreements are valid because there's a strong interest in having them not be valid. So it's kind of ironic that we're sitting here talking about why you should have one and then at the same time telling you the courts don't like them. But it's important for you to know, because if you're doing one, which is highly encouraged, most importantly, anyone can draft one, but you want it to be valid. So there is a framework on how you can make it valid, and there's an analysis for that. So I'm going to talk a little bit about that. There's really, first let me tell you what the common problems with prenups are, why the courts don't like them, and the things you want to avoid about them. The number one thing is people say they're entered into hastily, too quickly, too soon before the marriage. So one party maybe feels like they have to sign it. Number two, the financially disadvantaged spouse may not know what they're signing and be giving up too much. And then number three, the disadvantaged spouse in one way or another only signs it because they feel forced to do so or the marriage won't go forward. Those are really common concerns of the court. And obviously, it kind of feeds on the inequalities resulting from stereotyping and the image of a sophisticated, wealthy person taking advantage of, somebody who has maybe less education and stays home with the kids. Court wants to avoid a situation where there's no equality in a situation like that. So the way that it works, like I said, is there's a two-pronged test. And the first prong of evaluating prenups is ironic because it's about what is fair. And I tell everyone this because it's completely true. If you have any experience in the family law arena as a litigant yourself or knowing somebody that went through a divorce, there's not a lot of things that are fair about it. What you think is fair might not be what the court thinks is fair. And you could go into 5 different courtrooms with 5 different judges and get 5 different outcomes, and somehow they would all be fair. That is because there's a lot of discretion in Washington family law. However, that being said, in a marriage, there are general guidelines for what would be fair and what would not, even though it can vary. So when we talk about what's fair, what the court means by fair is what a court would do. And so we've looked, the court first says, is this prenup reflective of what a court would do? Well, let me tell you this. 90% of prenups, the whole point of a prenup is to do something other than what the court would do. So the vast majority of prenuptial agreements are not what the court would consider fair. And so almost every prenup fails that test, but that's okay. That's why we have a whole second prong of the test, which is far more important and mainly where the validity of most prenups lies. The second prong of the test, let's say your prenup has found that it's not what a court would do. So now we need to look at whether it passes the second prong. The second prong is what we call the knowing and voluntary prong of the test. So the court wants to know, did both spouses understand the legal rights they were giving up? Did they have full disclosure? Was there no pressure to sign? Was it knowing and voluntary? Did you know what you were doing and did you voluntarily enter into it? And so there's a number of factors the court will then look at to determine whether those things happen. The first one is each party having their own attorney. It's firmly my belief that both parties should have an attorney sign off and certify. The courts favor that. If not, it needs to be explicitly clear in the prenup agreement that the other party has had ample opportunity to review with an attorney, to retain an attorney, and they are explicitly waiving that right. You can still waive the right, but it's better to have both people have an attorney if possible. The second part of this is the parties must actively conduct active negotiations to show that the prenup is bargained for and not forced on a powerless spouse. This can be emails, this can be somebody asking questions, this can be somebody actually redlining a draft, it can be any number of things. So the court then evaluates, did anybody negotiate for this? That doesn't mean that if someone didn't want to negotiate and just say it's fine, that it's going to be thrown out, but negotiation is something that's looked at. The other thing is parties offering full disclosure of debts and income. So if you have a prenuptial agreement, but you don't tell anybody what you have, then your agreement's probably going to be thrown out. So disclosure of debts and assets is extremely important in a prenuptial agreement. And it lends itself to knowing that it was knowing, because if you can't really know what you're doing if you don't know what someone has, what their income is, and those kinds of things. And then the last thing, which is to me very, very, very important, is entering into and executing the prenuptial agreement in advance of the wedding. I think best practice is to have it completely signed around and executed at least 60 days before the wedding. A bare minimum is 30, but if it's inside 30 days, you essentially then want to look at doing a postnuptial agreement, because the closer in time you are to the wedding, the closer that a court might think somebody felt they had to sign it, or any number of reasons. So if you follow everything, then you're going to have a prenup that's most likely upheld. If you don't, well, then you might end up litigating about whether your prenup is valid. So the point is, do it and do it right and get it done. And then you have a very strong document that you can rely upon. Melissa, should I keep going or take a break to answer anything? You're on mute. You're still on mute.
Sorry about that. I don't have any questions up here right now. Just a reminder to folks, if they do have any questions, to go ahead and put those in the chat or the Q&A.
Okay, great. Well, then I will absolutely keep going. Here's the thing too, just before I start talking about why a prenup is a worthwhile exercise. It might sound like a lot of this is, I would call it kind of squishy, like it could go either way. That's because it is. And the ways that you can avoid heavily litigating a prenup later is avoid making it completely one-sided, make it fair and equitable, make sure both parties are accounted for as far as what their needs and wants are. And if it is somewhat lopsided, really make sure that everybody has counsel. And then finally, make sure that no matter what, it's executed well before the wedding. Sometimes people will call and they'll say, I'm getting married on Saturday. Can you review this or can you draft this? And I'll say no, because that's not in your best interest whatsoever. I might tell them to do a postnup, but timeliness is extremely important. So let's talk about why it's still a good idea. And one, obviously, like I said earlier, what I said at the outset is it avoids expensive litigation later, because that's not something that is good for anybody. But number two, having these kinds of negotiations and conversations are going to force a couple to evaluate how they're going to deal with finances during the marriage. And I can tell you, a lot of people will tell me later, they never thought about it, they never talked about it, it was never discussed, and then it just sort of happened, and maybe people had different interpretations about what was going on. But the kinds of things that you need to talk about when you're doing a prenup is, will both spouses work? Is there a plan that someone will or may stay home? Number two, is everyone going to use joint accounts, or are the parties going to maintain separate accounts and then a household account for any shared expenses? Number three, how will housing expenses, this is a big one. How are housing expenses going to be divided? Is one party that makes more going to pay for the mortgage and pay for everything? Are the parties going to contribute a certain amount to a joint account? What's going to happen there? Are you only going to use one account? That's really important. And the other thing too to think about is, finances are one of the main reasons that relationships fail. And one of the reasons I like doing prenups and postnups and cohab agreements is because it's focused on relationships not failing. It's focused on a contingency plan if they do, but it's focused on setting up some things so that you're less likely to fight about these things later. And hopefully, you know, it's like I said, it's that assurance policy that you never need. What can happen in a lot of situations that I've seen is parties might have similar incomes, keep their finances separate, and then without ever really talking about it, the mom ends up paying most of the kid expenses for whatever reason, or the dad does. And then that leads to issues. And then all of a sudden dad feels like, well, I'm paying, or dad then later starts paying for things and feels like I didn't have a say in these decisions. So these kind of conversations earlier on can be really important. Let's see.
So let me just chime in on that too, Michelle. I work with, you know, a lot of couples, like I said, who are trying to, you know, repair their relationship or determine if divorce is in their future, or to determine whether or not they're going to be able to move forward and together in a healthier way. And, you know, I just couldn't agree more. I think having these early conversations, these difficult early conversations about difficult topics, making some decisions that might change along the way, but, you know, having the opportunity to really be upfront and honest with each other from the beginning about what your plans are and what your hopes are and what your goals are is really important. And I think, you know, opens up the lines of communication early on. If you're having a difficult time doing that, consider, you know, enlisting a counselor or a therapist early in your relationship. You know, premarital counseling is obviously something people have heard of and it's really common, but it can be used in different ways. It can be used, you know, it doesn't have to be something that the church is requiring. It doesn't have to be something that only a couple in crisis is engaging in. I think it can be really healthy for any couple to engage in counseling at any stage of their relationship, and certainly early on, kind of getting ahead of the problems and getting ahead of those difficult conversations. It opens you up to learn how to communicate in a healthy way, in the early parts of your relationship, and not 20 years down the line where all this resentment has been built and people have been ingrained in unhealthy communication patterns. So
Well, wouldn't you say that like these conversations force people to be uncomfortable, but in a good way?
you have to be uncomfortable because being vulnerable is uncomfortable. Dealing with difficult emotions is uncomfortable, but it's also life and relationships, and it's going to happen. And so absolutely, I think it does force the discomfort, and it forces you to learn how to tolerate the discomfort and to feel probably more confident in your relationship once you've been able to tackle those difficult questions.
Yeah, I mean, these can be really uncomfortable conversations. And a lot of people will criticize the idea of a prenup as being a couple that's not committed. But honestly, statistics have shown that couples that actually enter into a prenuptial agreement, it increases the likelihood that the marriage will last longer. And right now, divorce rates are super high. They just are. And if you're entering into second and third marriages, those rates go up. Number one, because you've been through it before, so you're not as apprehensive. Number two, you might not have minor children. And number three, it just seems, like you kind of feel like I know what I want and what I don't want. So it's easier to pull the plug if it's what you don't want. So by doing a prenuptial agreement, it actually increases the likelihood that having those difficult conversations are going to set you up for success. I can't stress enough how important that is. And they're difficult. Like I said, and Melissa said, it's uncomfortable. I can't say enough too how getting help of a neutral third party if you need to have conversations that are difficult before a marriage or even during a marriage. I mean, couples counseling is amazing, and I think anybody can benefit from it. It's a hallmark of a good relationship. So that's definitely important. The last thing I'm going to say about prenups before I move on to postnups is this, the process. Like, what does it look like? A lot of people don't really know, well, where do I start? And so most of the time how it starts, there's different ways you can do this, but typically what'll happen is one person will talk with an attorney and have a consultation and say, this is what I'm looking for, this is what I'm thinking, and an attorney will offer advice on the best way to structure that, whether it should be a prenup or a postnup, depending on timing, whether what the other party might likely agree to or not agree to. If we're talking about things like spousal maintenance and attorney fees and property division, there'll be a good consultation and conversation that you have. And then typically what happens is one party retains an attorney to draft the agreement. So there's usually a drafter. And then the other party at that point will typically hire an attorney to review the agreement. And at that point, decide if there's feedback they want to give, if there's proposed edits, they'll talk to the other party about it. And then the attorneys will negotiate those terms. Or sometimes somebody will say, hey, I don't want an attorney, I don't need one, I'm going to decline that. And that's usually when that happens too. But parties can discuss the terms themselves as well. But part of the reason that that doesn't always happen, or it's sometimes a good idea to not have it happen, is you should be focused on, moving things forward and not getting stuck in the details where you don't necessarily have legal advice. You should have the conversations about these things, but it's not going to do you a lot of good to sit down and fight about it. That's a good point, to have the attorneys talk about what's equitable and come up with some solutions. A lot of the time I'll have a situation when one person says, I want the prenup to say no one ever gets any spousal maintenance, which is the Washington term for alimony. And the other party's like, oh no way. And they have a huge idea about what maintenance should be or whatever. And then the attorneys will talk and we'll say, let's work out a way. Let's work out some solutions to talk to our clients about that could kind of meet us halfway. And that might be an entry point for maintenance and a sunset clause. It might be a certain framework for it, so it doesn't always apply. So getting creative is always a possibility in prenuptial agreements. But at the end of the day, one party usually hires a drafter, other party usually reviews, proposes edits, and then at the end, the parties will need to execute with a notary. Right now, Washington is allowing for e-notary, which is really great and makes that easy. And then or you can execute in person, and then the attorneys will certify, and then you have what should be a valid agreement. So that is prenups.
I have a couple of questions on prenups. Why don't we ask those? Okay.
Yeah.
one person says, while I understand the need for a prenup as articulated here, how does one bridge the subject with a prospective partner from another culture where prenups are not common and where that partner's native language is not English?
That's a great question.
Question.
That's a tough situation. And cultural norms come up actually a lot. I've had that come up a lot. And one way to do that, I think, is to explain to the other party. I mean, if the first English language is not English, that makes it difficult. I'm not sure what the most effective way is for you to communicate, but explaining that it's literally a contract to protect both of you, that it's not a unilateral thing, that it's not uncommon, here, even if it's not in their culture or where they're from. And to have an attorney tell them, I want you to have an advocate the same as I do. And a lot of the time too, it's not uncommon for the person who's paying for the drafting, or maybe the person who wants the prenup more, to pay for counsel for the other person. There's no conflict as long as it's an independent attorney, but you can pay for it for them and say, hey, I want you to have your own professional advice. You don't have to listen to me about everything. And this is supposed to be fair for both of us. And it's really just a contract, just like it would be if you were buying insurance policy. If you're buying a home and entering into escrow, you're effectively signing a contract that deals with your property rights. And dealing with it more that way, and saying too that I want it to avoid the conflict during the marriage by saying this is how we're going to do things. It's a framework for those conversations. That might not help you a lot, but that's kind of what I got.
Okay, thank you. One other question on here. Does the prenup protect assets prior to marriage, or are those on the table as well?
Yes, that's a huge part of it. That's a huge part of it. Yeah. So you'll do an asset and debt disclosure like I talked about, and that's going to disclose everything that you have. And typically what happens in a prenup is you'll each have an exhibit to the prenup laying out what is to remain separate property. Same in a postnup or cohab agreement, but it'll say what is to remain separate property. And so those things that are on that exhibit are usually the assets that you're bringing into the marriage. So if you're doing that, and you're putting on, let's say you have a 401k or you have a pension prior to marriage, and maybe you'll contribute to it during the marriage, and you may want the whole thing to stay separate or just until you enter into the marriage. Either way, a big function of a prenup is to define what stays separate property before the marriage, and then what happens to property during the marriage. So great question. And yes, your separate property is absolutely addressed very explicitly throughout the prenup in a good prenup. So anything else?
There's one more question here. My partner and I have been together 4 years. I paid all the bills as she completes her education. She has school debt. I don't have debt, so I'm more established, closer to retirement. If I do not sign a prenup, will everything I own, like my home and investment, be community property during a divorce, or only the things that we both accumulate during the marriage? So it's kind of more of a community property question, which is, I guess, a reason why.
That skips me ahead and I'll talk about it briefly in response to that, to committed intimate relationships. You might not think that, the other party has an interest in anything pre-marriage, but that's not true necessarily. Sometimes it's true, but committed intimate relationships in Washington are Washington's way of saying they recognize marital-like relationships that occur pre-marriage where parties cohabitate. So if you're living with someone for 4 years and you're paying most of the bills and maybe they're contributing what they can, but you're in a relationship where parties are pooling resources in some ways, there's a number of things that apply to committed intimate relationships we'll talk about later. But what I would tell you is it depends. And if you're not going to get married, you at least would want to look at a cohabitation agreement to define the rights, property rights of each of you, because property rights can be acquiring, especially in a 4-year cohabitation. If the relationship were to end, one party could file a petition to partition assets and dissolve a committed intimate relationship. And then everything that was acquired from the beginning of cohabitation until, the end of the relationship, you would be in a question of whether that was community or not. I'm not necessarily going to say it is, but sometimes what happens is people want an easy answer. They want to say, no, this is mine. This is why it should be mine. They never paid anything. But frankly, if there's a petition filed in a court, a lot of the time, you're not going to get a quick answer, and you're going to end up maybe in a trial court situation dealing with that, or a mediation dealing with that. So there's not a hard and fast answer, but there definitely are property rights that are potentially there and can be litigated pre-marriage. So here's another good, your question made me think of something else that's really important about a prenup. If you're entering into a prenup, and you live together beforehand for any significant period of time, a year or more, which most people do now, your prenup is going to usually include a committed intimate relationship waiver and a waiver to premarital claim on that time. So let's say you move in with someone, you live together for 3 years, and then you get married. If your prenup is totally silent on that period beforehand, even if it defines separate property, that could be problematic for you. So someone that knows what they're doing drafting an agreement will be sure and address that cohabitation period. So, and prenups also, just as a last point, are not valid unless you get married, because it's in contemplation of a marriage. So that's part of the contractual portion of it. If you never get married, I mean, it never triggers. That condition precedent never happens. So if you're not sure if you're going to get married, do a cohabitation agreement and then just convert it to a prenup when you're sure. So hopefully that helps.
Right.
Yeah, cool. Okay.
There's a couple more things, but I think you could go ahead and move on with some content, and we can come back to the questions in just a little bit.
You can ask them, and then I'll just ask if there's like one or two, I can answer them quickly, and then I'll go into postnups.
Pretty quick. This says if in the eye of the court, one party obviously has more assets and money than the other person, would that still be valid? I don't know if they're talking about, would your prenup still be valid?
Yeah, probably. Well, it kind of goes back to what I said before. Almost always somebody has more assets and money. That's just common. And so if the prenup leaves you in a position where one person's going to have way more than the other person, it's not going to be fair. So if it wouldn't pass the fairness prong, but like I said, 90% of or more of prenups don't pass the fairness prong. That's why we get to the second prong of knowing involuntary, and we look at time of execution, we look at asset disclosure, we look at counsel, we look at those things. So you could still have a valid prenup if it leaves one party with a lot more, but you're going to want to make sure that your execution is pretty much flawless. Hopefully that helps.
Yep. And then one more. Is a business safe, or is there a starting point of equity? Say it's worth $1 million, and then at divorce it's worth $2 million, as an example.
Yeah, you would be. I always deal with businesses in agreements. Businesses that either exist before the marriage or businesses that are established during the marriage. Because if you establish a business during the marriage, this is the important thing to keep in mind. I didn't even say this earlier, is that name on title does not matter in Washington. Community property state, name on title is not determinative of anything. Same with a business. You can incorporate a business, be a managing member, depending on how you're incorporated. And your spouse, if that happens during the relationship or the marriage, your spouse could have a claim to the value of the business, the goodwill of the business, depending on if it's professional services, profits, all of that. So you need to be clear about your intentions with a business during a prenup drafting. The other thing that can happen is you can have a prenup and it can say, the business is somebody's separate property, but the income, if you usually would want to pay yourself a reasonable salary if you're an LLC or something. So your income is going to be community, but the business and the value of the business or the business profit beyond the reasonable salary is separate. There's a variety of things. Businesses, I deal a lot with businesses. So there's a lot of things that you can do depending on how your business is structured, but it definitely needs to be addressed. So that's actually a really great question. Anything else, or should I talk about postnups?
Let's go ahead and move into postnups.
Okay, so a postnup should not be confused with a prenup. They're the same in the sense that they define property rights, but parties must already be married to enter into a postnup. And I mentioned this earlier, if there's an issue about closeness and time to the wedding, I will usually almost always recommend that you do it as a postnup, so then you don't deal with those validity issues. The purpose of a postnup agreement is really to determine how the property would be divided, the same as I would say a separation agreement. So if you're separating, often you'll sign a separation contract to decide how the property is going to be divided. And a postnup is very much the same. It can also be drafted similar to a prenup. The difference is the parties are still married. So enforceability of postnups is another thing. It has to be written essentially as a legal, you can't just write it on a legal pad or a napkin and say it's a postnup. It's the same thing. You have to meet the rules for contract validity. There's no closeness in time or duress issue, but by the same token, if the validity were challenged, the court would be looking to the circumstances surrounding the signing of a postnup. If it's just a deal where somebody drafted it, another attorney did it, and everything seemed fairly standard, then duress usually isn't an issue with postnups because there's no question about timing. However, if it's a situation where someone, you know, stood over someone and was like, you're going to sign this or I'm going to file for a divorce, or you're going to sign this or we're not going on that vacation, or whatever it might be. In a situation like that, the court will consider whether it was a knowing and voluntary execution, whether there was duress. All of those things are important. The other thing that's really important, just like in a prenup, is looking at the disclosure of debts and assets. You have to make a full disclosure of debts and assets. This can be a sticky situation where if you're already married and maybe one person has a lot of debt that they've taken out that the other partner doesn't know about, you know, that's something that is going to be really, really important. Because if you don't disclose it and you have all that debt, you're not gonna be able to say later that, oh, you know, I didn't just, it wasn't listed, so it's not mine or whatever. You really have to make a full disclosure. A lot of the time during a marriage, it's not a big deal because everybody already knows what they have, but sometimes that can create issues. So you want to keep that in mind. So typically same idea. Once an attorney has drafted with one party, then another attorney or the other party will review, propose edits, and really go from there. This is the other thing too. Agreements that are postnups are very common in second marriage situations because you could be remarrying and have children from a first marriage. And so a lot of people want to define property rights. And sometimes this is done with a postnup that survives death. So then it can be binding on your estate. So that can be important. It's also, this is a side note, whether you're doing a prenup or a postnup, it's very important that you also evaluate your estate plan situation because you're going to decide if your agreement survives death or not. And if it does, you're going to want to make sure it doesn't conflict with a will that you do. Very often I will have a client update their will and we'll include it as an exhibit and we'll say that these are not in conflict, or we'll say this takes precedent because it's later executed or whatever. There's different things you have to look at, but where you have other children and you might want to be looking at what's going to happen with community property and so forth, it's important. And it can also be a really good way, again, to have those conversations that you might not have had. So yeah, is there any questions before I start talking about cohabitation?
I do have a couple.
Okay.
Assuming one party would be considered a sophisticated and knowing party who also comes into the relationship with significantly more assets and income, could that party engage an attorney to represent the other party exclusively, and then that more knowing party enters the prenup without independent representation?
Yeah, but if you're, I mean, and this isn't to be rude, but if you're knowing and sophisticated, you would have an attorney to make sure to make absolutely sure it's valid. So yeah, if you're the knowing and sophisticated party, then you should know that if you want your prenup to definitely be valid, you should both have an attorney. I mean, that's just the reality of it. But you can definitely engage an independent attorney for the other person. But if you're just gonna be like, hey, I don't need one, maybe you don't need one, maybe you know enough to know what's going on. But what you should be learning from this is you should have an attorney if you really want to be sure it's valid. Having that attorney certification signed is super important. You don't have to do it, but it's super important. And if you do, and you're knowing, then you should, if you can afford it, then you should do it. So that's my advice there.
Somebody also asks, can the prenup, postnup be filled out by the couple and still be valid? And if so, where would you get the forms?
Probably not. I've actually litigated a case a few years ago where one party drafted their own, and two things can happen. That one, it was completely thrown out because nobody had independent advice, and they downloaded a template and tried to fill it out. Those are usually thrown out, honestly, again, because Washington courts disfavor agreements and nobody had independent advice, and that's not helpful. And usually if an attorney reviews it, they're going to make a bunch of changes, so then it's no longer that drafted agreement that you did offline. But a really important thing to know when you think about this is it's not gonna, even though it's gonna cost you a little bit of money, I can't stress to you enough how expensive litigation can be and how it is, hopefully, if you do it the right way, even if you think you don't need that attorney to review it and certify it, or even if you think you didn't need an attorney to draft it, if only one person's doing that, it will save you so much time and money. Another thing I was going to tell you was a case I litigated where the other party, not my client was unrepresented in this case before when they got married just a few years back. And the other party drafted her own, the other side drafted her own prenuptial agreement. And in that case, and my client, and she had an attorney, but my client didn't. And then what actually ended up happening. And it ended up with things that happened during the marriage being disfavorable for her, even though she drafted it. And so she wanted to throw out her own prenup. And the court said no. And the court said, you drafted it, basically kind of trying to slap her around a little bit and saying, you drafted it and you didn't talk to anybody, and, or you thought that it was your own thing at the time and it was helpful to you. But the court construed all of the ambiguities against the drafter because that's contract law. So you want to be really, really careful. The other thing too is that family courts have a lot of discretion. And so if a judge really doesn't like an agreement or really does want to uphold it, they'll find a way to do it. So the best thing you can do is make sure that you adhere to the complete test for validity and check all the boxes. And then it's really hard for a court to do anything about. But a situation like that ended up being really bad for that other party that drafted it. So I would encourage you, the same way that I would not perform surgery on my knee when I tore my ACL, I would recommend that you not draft a prenup. That's just the same thing. I mean, no, I can't be any more, unless you want to spend $30,000, $40,000 fighting about it, don't draft it. Just pay someone a fraction of that to draft it and you'll be good. Okay, let's see. Is there more, or should I talk about?
I just got one more question. How often do you get into a situation when parties generally agree on terms and then they bring in the reviewer attorney and the whole agreement gets derailed? Do attorneys typically like to try to make it work or poke holes?
Well, the attorney is trying to make it work, but an attorney has to do their job. That's a good question. I like how you say derailed, because actually that derailing is helping you. What I said earlier is the whole negotiating for a prenup part. If you have an attorney that's like, hey, I mean, I'll tell you this, I'll never look at a prenup almost ever without making at least some suggestions on things that could be better for my client. Because if I do, I mean, if everything, once in a while, I'll be like, wow, this is really great. You guys have done a lot of legwork, but usually there's things people haven't thought about, or usually there's something that's not advantageous to my client that I'll want to push back on. I almost have never received a draft from another attorney without comments, because that's our job. It's our job to look at it from your point of view. And because, like I said in that validity question, the more that a prenup shows that it's negotiated for and that it was contemplated and talked about, that speaks to validity. So you kind of want that a little bit, actually. I have never, oh no, that's not true, never. I would say there have been, I've done a lot of these over the last 12 years, but I would say there have been maybe, I can't think for sure, but less than a handful of agreements that have fallen apart, and that where there's been no agreement. And that's usually because the relationship fell apart and the parties decided not to get married or to break up or any other things. Well, I've never actually had people try to enter into a prenup and be so at odds over the terms after working with counsel that they've pulled the plug on it. A reviewing attorney's job is not to try to get the plug pulled by any means. It's to try to help that party negotiate, maybe improve some of the terms, or suggest, things that maybe weren't thought of or whatever. So I would say it's common for the reviewing attorney to have comments, not always, but most of the time. And it's actually a good thing. Because it helps with the validity. And if you have somebody that says, oh, there's never any issue and there's like really glaring things, and they certify the prenup, that's one thing. Oh, this actually makes me realize this too. So I can tell you this, someone will bring me a prenup that someone else drafted that I think is totally disadvantageous for my client. Like, the client should not sign it. The client should not agree to it. It doesn't mean I'm not going to certify it though. The client should not sign it, should not agree to it. But and I've proposed edits, and my client is like, you know what? No, I don't care. I'm willing to give up I'm willing to basically have no community, even though I make nothing. I'm willing to do all of this. I usually sort of feel like there's something else going on there too, but whatever. And the client really wants to sign it. So what happens then? This comes up sometimes and people want to know. I will still certify it, but me, or pretty much some attorneys will say, no, I won't certify it. But what I'm certifying is not that I'm saying it's a good agreement for you. What I'm certifying, and what's in an attorney certification, is that I've reviewed your property rights with you. I've told you what you're giving up. You're entering into this knowingly and voluntarily. And then I will have the client, before I certify it, sign something telling them it's against my advice. So later they can't come back and say, oh, she told me to sign this. It should be invalidated, and the attorney should be thrown under the bus. Because I'll certify it for you and I told you all of that. It's not my agreement, but I'll only do that after I've thoroughly reviewed it with you and then given you something to sign acknowledging that I told you. And then if you still want me to certify it, sure, that's your choice, but you've been put on notice. We'll have people come back later who want to invalidate something. and they'll say, yeah, this attorney told me not to sign it, and I did it anyway, and I wish I hadn't. Well, and there's a letter even saying from somebody else, oh, I told them not to, and they did it anyway, and I certified it. That's not probably going to get thrown out, because it was definitely knowing involuntary then that you did something that was against your interests. So anyway, hopefully that's helpful.
Yeah, I don't have any more questions right now. I think we should go into Cohab agreement.
Yeah, let's talk about cohabitation agreements. So this is important, and this is probably the least talked about, and it maybe should be the most talked about because it's the least known. And Washington has very specific and liberal property rights that are afforded to unmarried partners. So what's a cohabitation agreement, right? What is it? It can mean a lot of things. Is that for a roommate? No. You could do one with a roommate, but that really wouldn't make a lot of sense. If you're living with your partner, or you're thinking about moving in together, I strongly advise that you take time to consider the implications and look at a cohabitation agreement. You should be aware of what your relationship could look like from a legal perspective. And you should be ready to make an informed decision about your property rights. And you can do that through a cohabitation agreement. So basically, what is it? The contract between an unmarried couple that lives together and details the legal rights and responsibilities of each party with respect to property and income and things like that. First thing to know, let's think about this. And I didn't talk about this earlier, but when you're dividing property in a divorce or in a committed intimate relationship, first thing is what's in the community. That's like, what's the community? And so that typically spans when the parties started cohabitating together to when the relationship ended. And so you could really draw a circle, and everything that was earned or received during that time goes in there. And then things get backed out, like if you had inheritance during that time and you kept it separate, that's going to be backed out of the circle. If you had a gift to you from somebody that was a specific gift to you and not the community, that's going to be backed out of there. But the presumption is going to be that anything acquired during that time is community. So you notice I didn't say when the marriage starts, I said when you start living together. So when couples break up and they've lived together in a non-marital relationship, but what could be a committed intimate relationship, one party can file a petition to dissolve the relationship and divide the assets, and then essentially claim, here's when it started, here's when it ended. And although they still have to prove a committed intimate relationship, it's potential that assets and debts too, it's not just assets, could fall within that time. So when I think about the best way to explain cohabitation agreement to people, I think about telling them that this is going to serve to protect your assets. And maybe in a situation like this, where it's a little more unknown if you're going to stay together, or maybe you never want to get married and you know you're going to stay together. Other times, maybe you don't know. Maybe you've lived together a year or two, you know, things are going well, but you still don't really know where the relationship's going. So cohabitation agreement, it's never too late to do one. The common question I get is, do I have to do it before I move in? No, absolutely not. Some people don't even know it's a thing. So once you find out it's a thing, they think, oh, I want to do this now. And it can give both parties peace of mind. This allows you and your partner to dictate what will happen with property if the relationship dissolves. And I can tell you this, committed intimate relationships can be the most frustrating cases, because one party might be like, I didn't even know I was in this. I definitely don't think it was this. He or she was cheating. He or she didn't contribute anything. All these things that are said in almost all these cases, because that might be what happened. And it can be really frustrating, and you can end up spending a lot of time and money on a situation that you didn't want to be in. You might say, oh, well, all my accounts were in my name, all his accounts were in his name or her name, and shouldn't that just be the way it is? And the answer is not necessarily. So a cohabitation agreement allows you to define that and basically to say, we're not going to go down that route. And if someone does file a committed intimate relationship claim later, then number one, they still have to prove it. And number two, the cohabitation agreement should dictate the terms of the property division. So there's really not anything to fight about. Another thing that I should note about committed intimate relationships and in the context of cohab agreements is that there are two really important things that you can get in a marriage that have to be addressed in a pre or postnup that don't exist in committed intimate relationships. Number one is spousal maintenance, the Washington term for alimony. In a committed intimate relationship, one party cannot receive, even if they prove committed intimate relationship, they can't receive spousal maintenance from the other party. It's not on the table. That's a big issue in divorce. So that's something that you don't deal with. The other big thing you don't deal with is attorney fees. If you're funding a committed intimate relationship case, each party has to have their own fees. in a marriage, you can seek fee. I mean, unless one party is what we would call intransigent, you could seek fees for that. But in a marriage, Title 26 has a very clear statute on need and ability to pay. So there's a need and ability to pay standard that allows, you know, a less moneyed spouse to seek attorney fees from a more moneyed spouse. That does not exist in a committed intimate relationship case. So that's really, really important to know. A lot of people think that, oh, I don't need a Cohab agreement, or we have a common law marriage. Well, number one, Washington does not recognize common law marriages. Most states don't. I want to say, I think there's 3 that do right now. We're not one of them, but we recognize committed intimate relationships, which isn't what I would say a common law marriage, but it definitely deals with property rights. And like I think I've stressed enough, you don't want to be in that situation. I think it's important too, when you think about your agreement, the things you're going to deal with in a cohabitation agreement is property. This is the number one thing, is where you're living. If one person owns a home and they bought it during the relationship, and somebody contributed part of the money to the down payment, guess what? It's probably going to be found community, unless there's a reason to show that it's not, or that wasn't the intent, or any number of things. But, or if somebody didn't even contribute anything towards the down, but the down payment came from wages or assets that were earned during the committed intimate relationship, then it's potentially a community down payment anyway. So there's all kinds of questions about how a house can be found community that's purchased during a relationship, and that presumption. So what you want to do, number one, is define the issues with any real property. If one person is paying for it, they're the name on title, and the other person paying to help out, you want to make that really clear, that no payments are establishing any kind of a community lien on the property. They're not going to do anything that transmutes the property to community. That basically the court would recognize, if your agreement's drafted properly, and even without an agreement sometimes, that a party contributing to living of a separate property residence of another is just basically paying reasonable rent, because you'd have to pay rent to live somewhere. If you're paying more than that, or you're paying to make improvements on the house or things like that, that's another thing. So defining property rights surrounding where you're living is super important in a Cohab agreement. Defining whether income is going to be separate property or community is really important. Typically, when someone's doing a cohabitation agreement, they really want to, a lot of the time, most people that I work with and talk to, they want a name on title agreement. And what I mean by that is they want their agreement to be reflective of, if it's in my name, it's mine. If it's in his name or her name, it's theirs. And that's what you kind of think is the law, right? You think, gee, if we don't set up a joint account, then we have our own stuff. That's not necessarily the law because of committed intimate relationship law. But a lot of time people just want a very clear name on title. Income is not community unless I place it in a community account. The only community-like property is something titled in both of our names, and just being very clear about that, because otherwise you could be socking away money into a 401k, you could get restricted stock units annually as part of your job, and that could be significant. And all of those could be, presumed community, as could the home that you purchased during that time. So a lot of people will want to do a very clear name on title agreement. Other people might not. They want to say, hey, we're never going to get married. This is going to govern everything, and we want all of our income to be community, but maybe they want to carve out an exception for retirement. There's a lot of different things you can do. So you're going to look at housing, you're going to look at income, you're going to look at what you want to have happen with retirement, you're going to look at whether you want name on title to control. Another important thing in a cohabitation agreement that I can't stress enough is if the parties are agreeing that where they're living together is one person's separate property, you're going to want to have a provision for how to deal with the relationship ending, and what that might look like as far as somebody moving out, the items in the home, things like that you don't really deal with as much specifically in a prenup. You're also going to want to deal with the parties. I've done a lot of agreements where the parties have actually bought a home together, and then dealing with what happens with the equity of that home if it's community-like, and then dealing with what's going to happen if one party is going to buy the other out and what that's going to look like. So there's a lot of different things you can do, and it's very fact specific as far as how you're going to want your agreement to be, but it's a great idea. I mean, I can't stress enough what a great idea it is, and how unfortunate it is that it's not your fault. You didn't know this was a thing. You didn't know you needed this. So that's part of why I think it's important to talk about this stuff. You could spend a couple $1,000 and be done with one of these and have it be a really good, effective agreement, or you can spend tens of thousands of dollars litigating to fight for your property that you thought was yours in the first place, which is a really tough situation to be in. And nobody wants that. So same thing, you could spend tens of thousands of dollars to fight about stock options that you thought were yours. So anyway, that's my 2 cents. Melissa, we're getting close on time, but do we have any other questions?
A couple of last questions here, and we are getting close on time.
Sure.
What rights would I have if I move in with my partner who owns his home outright? I'm assuming, without an agreement, obviously.
Sure. If he owns his home and he owns it and you haven't moved in with him, well, I mean, what rights do you have is a really big question, but that's a separate property. You would have a hard time showing that it wasn't his separate property. If it's completely paid for beforehand, you're not paying anything to live there, and he's owned it way before you moved in, you might not have any claim to the property. But let's say something comes up and you live there a while and you're like, hey, your house is great, but I really want to remodel the kitchen, and you take out, a loan, or you spend some of your money to do a remodel or something, then you've potentially got a community lien on the house. So for what you did or the increase in value. And so that can get complex. So on its face, it looks like, maybe nothing, but it could be more than that. And you still, if you're going to move in with your partner and live with them for a while, and somebody claims committed intimate relationship, and that can be proven, any money you put into retirement, any money that you earn, anything at all could be found community, and that's separate from the home. But the home doesn't dictate whether you have a committed intimate relationship. It's just one of many issues. So hopefully that helps.
And then maybe this is a good question to finish on here. Fully recognizing that it varies by complexities of assets in the situation, how much does a typical agreement cost?
Great question. Well, I'll tell you this, everybody does this differently. A lot of attorneys will draft a agreement, and there's different, you're also going to, it depends on how much it's going to cost, depends on if you're the person paying for the drafter or just paying to have it reviewed. A lot of the time, that varies. What I do is I do a consult with somebody and I assess, what's your situation? Are we talking about dealing with, I actually just finished an agreement where we were dealing with a ton of different businesses that were pre-marriage. We were also dealing with 5 or 6 different properties. So there's a lot to sort out and to define, and they'd lived together for a while. So it was a mess, but that's something that's more complex. Sometimes it's not that complex. Those agreements, me and many other attorneys will do them on a flat fee, so you're not paying hourly. I like to do these agreements. I'll be clear with you. I like to, and I think other attorneys like to do these agreements on a flat fee when we can. And that is typically when we can kind of conceptualize how long it's going to take based on the complexity of the situation. Because I don't like it if clients are feeling like, oh, I want to ask questions, but I don't want to pay more. This isn't the time for that. So I typically, will try to do a flat fee when I can, unless it's a really complex situation. And then I can't estimate how long it's going to take, how many revisions there are going to be, what the other side is going to want to do. So if it's a question about complexity, I'll typically take what's called an advance fee deposit, where you put a deposit into trust. That's also, just as a bit of advice, commonly called a retainer in Washington. That's actually not the correct term. A retainer means something different in Washington. A retainer technically is what you pay to an attorney to just have them available to you to answer questions. It's a monthly fee. In Washington, that term gets confused with advance fee deposit a lot. So I want to be clear that when you put down money into an account and it gets billed against hourly, you've paid an advance fee deposit, and then it gets billed against hourly for fees and expenses. So in a typical agreement where I don't know what's going to happen and I take an advance fee deposit, I typically will take about a $3,000 advance fee deposit. Some people will take less. I know some people will take a $5,000 deposit. You take a deposit and then we bill against it hourly for fees and expenses. Maybe it costs more than that, but maybe it doesn't, and you get some money back. In flat fee situations, I typically will draft agreements between $2,000 and $3,500 in flat fee situations. And that means that it's all the drafting, all the negotiation, all of the execution and certification, all the back and forth with the other attorney. And I've done that because I've done this a lot. So I kind of know after a consultation, can gauge what's going to be needed and what the range of risk is for how long it's going to take. If I'm just reviewing an agreement, it depends on what the situation is again, because if it's really a really complex situation, I'll again take an advance fee deposit because I don't know, I didn't draft it. I'm going to have to go through it all. Sometimes I've gone through these agreements and it's been really bad and I've completely rewritten the whole thing. Other times I'm like, oh, there's only a few things we want to talk about. So I don't really know. So a lot of the time I'll take an advance fee deposit there, or if someone has shown me an agreement in a consultation or something and it's pretty straightforward, I'll take a flat fee that is usually less than I would take to draft. So hopefully that is helpful information. Thanks for coming. I hope that you got something out of this. So if you have other questions, I know Melissa's going to put up some contact information, and I hope you have a good rest of your week and great weekend. Thanks so much.
Thanks, everybody. Thanks for coming. Please feel free to reach out if you're interested in a consult or further information. And we do host webinars once a month or so. So stay tuned for our next one. Thanks,
Take care.
everyone. Take care. I'll leave this slide up here for just a couple minutes.